Welcome to this short webinar from ourselves, Comply Plus. This is part of the legislative guidance series we do on a monthly basis, where we take a particular subject and we go through some of the basic principles or requirements relating to it. So this one in particular is called Accident Incident Management. So I suppose what I'm going to do is going to outline what the course is about and tell you what it's not about then, because accident incident management is quite an extensive area. So we're going to cover legislative requirements. I'm not going to go into every specific requirement. I'm just going to go into key requirements that if we get those right, we tend to have everything else right along the way. We're going to look at state enforcement. So what happens in the event of an accident? How does that progress? Nobody wants to be on that end of it, but it's important that we know what it's about, first of all, because that helps us look at mitigation factors and reducing the risk of accidents occurring in the first place. We're definitely going to look at civil proceedings and the way they progress, and our objective is to mitigate the risk of both state and civil proceedings. We're going to look at the common mistakes that are made when dealing with an accident or incident. We're going to look at the effectiveness of safety management and supervision and the part they play in mitigating the risks associated with accidents and incidents. Then effectively dealing with an accident or incident. Then evaluation of liability. So how to evaluate, where does liability lie, and is it worth evaluating that? And finally, the steps to mitigate, to address liability so as to reduce the risk of liability. Again, milk is spilt, so we have to mop it up, shall we say, but we want to ensure that we contain it and we try to prevent it from happening again, and find out, well, why did the milk spill and who was involved in that? Can we prevent that? And then there's a Q&A. So that's what we're going to be talking about. Now, we're not going to be going into the minute details of accident investigation and the process associated with that. It takes a long time to go through all of that. We are looking at what we call the top line issues, including in legislation, again, to give us a guide. But again, if we can manage to get the top level right, that helps significantly the potential liability issues associated with accidents and incidents. Obviously, our objective in the first place is to prevent accidents and incidents happening, and that has to be a priority. So just the legislative requirements, what are they? Well, the Safety, Health and Welfare at Work is the prime legislation associated with the responsibilities of employers to reduce risks in the workplace and the duties of employees. And if we look at Section 8 in particular, and specific sections out of Section 8, every employer must ensure, so far as is reasonably practicable, the safety, health and welfare at work of their employees by the management and conduct of work activities. So here, the legislation tells employer they have to manage and conduct their work activities in order to ensure the safety, health and welfare of the people that work for them. They have to ensure the design, provision and maintenance of safe workplaces, safe means of access and egress to and from the workplace, and safe plant and machinery. For ensuring safety and prevention of risk from the use of any substance or article, from noise, vibration, etc. So it's very clear what the legislation is saying, that the employer has got a significant responsibility to ensure that when individuals are working for them, that they have a duty of care to them with regard to safety. And there are clear provisions in there, providing a safe system of work so that the process that they're working to is safe. Provision of adequate instruction, training, supervision, and the necessary information. And that's also in Section 9 and 10 of the Act. It's further expanded. But here, again, this is a clear direction to employers what should be in place. And then we've got Section 12, which is the general duties of employers to persons other than direct employees. For example, subcontractors and others. Okay, so the reason for talking about this in terms of accident incident investigation, well, usually it's a failure to comply with one or some of these items that is a contributing factor to an accident. usually, not always, but usually. So we have to consider that and make sure that's in place. Then, of course, we've got reporting responsibilities with regard to reporting of accidents. That's an accident that where somebody's off work for 3 or more days following the date of the accident. And again, I'm not going to go into the full details of that, but it's fairly straightforward in terms of the accident reporting requirements, so that the HSA gets data with regard to accidents. So that's a very brief overview of the employer's responsibility. Looking at the employee, this is covered under Section 13 of the Safety, Health and Welfare at Work Act. And again, I'm only taking specific areas out of it that relate, that, you know, that I suppose relate to accidents. So employees must comply with safety and health legislation, both the 2005 Act and any other applicable legislation. They must take reasonable care to protect their own safety and that of any other person who may be affected by their work. They must cooperate with their employer or any other person to ensure or to assist that that person or organization can comply with their legislative requirements. And they must take account of all training and instruction given by the employer and correctly use any equipment or article or substance provided. And they must report if something is dangerous. You know, so that is, or something is damaged as well, a defect. So they, I suppose, outline the key requirements of employees. And in a lot of cases, sometimes when you come to an accident investigation, some of these are not complied with. Hence the reason for the accident. While the employer might comply, the employee sometimes doesn't comply. So the reason we're talking about these is we're going to be looking at them later on when we look at accident investigation and causation. So what's our concern? Civil liability is accidents and incidents causing harm, loss or harm to another. Personal Injury Assessment Board, or PIAB, P-I-A-B. Personal injury guidelines, they're changed on the 24th of this month. It's part of the time we were doing this. The PIAB used to have the Book of Quantum and a guide to personal injury claim values. You know, a soft tissue injury on the finger would be X, significant damage or long-term damage would be Y. Now, these figures have been revised, and these new guidelines are coming into place from the 24th, which apply to all cases going through, whether through PIAB or through the courts. Again, this is just from the news. New guidelines should see personal injury awards fall. So it's to try to take control over personal injury awards, try to reduce them, to bring them more in line with other countries, and as a result, hopefully reduce insurance costs, etc. Now, whilst that is fine and good, the problem or the difficulty is, you know, that doesn't stop accidents occurring. And our objective is to stop accidents occurring. And if accidents do occur, you know, are we dealing them in such a way that if it is a genuine accident where the person, you know, genuinely did not contribute to the accident, you know, they have a right to go to insurance, absolutely. But someone who injured themselves because of their fault, really, that shouldn't be progressing to a civil case. The courts in civil cases, district court up to 15,000, circuit court up to 75,000, high court is unlimited. They're the court jurisdiction levels with regard to civil claims. Civil cases are based on a burden of proof on the balance of probabilities are 50.01%. So basically, in the end, it's my story against their story, and what I can back up my story with and what they can back up their story with. And a solicitor taking a defendant, or sorry, a claimant on in terms of they go into their office and say, well, I've been injured at work and I want to take a claim against the company. The solicitor at that stage will listen to the story from the individual and figure out whether or where the balance of probabilities lies, and have they got an easy route to a claim. So they'll be looking at 70, 75%, you know, And again, it's what influences that decision to proceed, mostly on a no win, no fee basis. I'll take 30% of the fee of the award on a no win, no fee basis. But they only go when they've got really good, solid evidence, and the likelihood of winning is almost guaranteed. And this is where we want to try to influence that, if at all possible. Statute of limitations, 2 years from date of knowledge. Now, a strange term, date of knowledge, but so if an accident occurs and someone breaks their leg today, well, the accident occurred today, and date of knowledge of a broken leg is today, so therefore it's 2 years from today. But it's not as simple as that in law. The date of knowledge can be the date they have been injured, as I've just described. It can be the date the injury in question was significant. So in other words, I could have an injury today, but it's insignificant, but it materializes itself 2, 3, 4 months down the line, or even a year or two down the line. And I go to my doctor and they say, oh yeah, well, that could be from this. And then suddenly that's my date of knowledge of the incident. That the injury was caused by negligent, by the party at fault. So if someone caused an accident to occur to me, and I found out then that they were negligent in their actions, when I find out they're negligent in their actions, that's date of knowledge in terms of a claim. So the 2 years isn't as clear as people think in terms of, well, that happened 2 years ago, so it's bound to be finished with, we can throw away the paperwork. It's not as simple as that. That they know the identity or the party at fault for the accident, because sometimes they may not know the individual who might have caused it, and therefore have no recourse to take an action. And then this is the final one on that. So with civil proceedings, an accident occurs. Individual is injured. Individual alleges an injury, or individual delays reporting an injury. So I'm trying to, I suppose, be not clever with the wording, but I have to take account of the potential possibilities that occur. There is more. Individual does not report an injury. So let's go through those. An individual is injured. It's very obvious. A cut, a break, a bruise. It's very obvious. Individual alleges an injury. Oh, I've hurt my back. We can't definitely say the back is hurt or not. So there are issues about the alleged injury until it's confirmed as an injury. Individuals delays reporting an injury. Common one where, oh geez, I hurt my back last week here. Yeah. Well, when did it happen? Oh, in the morning. And what were you doing? And who were you with? And why didn't you report? Well, I didn't realize at the time. I forgot. And that happens. An even better one is individual is not reporting injury. So individual goes to the doctor, complains about a sore back. Where did it happen? Oh, I hurt myself at work. And he puts on the sick note, workplace accident, hurt back on the 24th of April 2021, and signs them off for the 2 weeks. And the employer might actually see that sick note or the details of that, but it becomes a record on their medical record that they had the injury at work. And again, that is an unknown. And it's a problem because there'd be no accident report probably done for it. There'd be no paperwork to support it. Yet the evidence on behalf of the employee is that they have a doctor's note that he injured his back at work. And does that get you over the 50.01% line? There's a good chance it will, unless the employer's got something to prevent that or help mitigate that. The solicitor's letter, it arrives in. Hopefully you've never seen them come in, but here's an example of one. Yeah, it comes in and it makes some serious allegations. There's first of all, the time limited. You must respond to this within 14 days or we will proceed as if you are guilty, basically. Details of the alleged breach. In this case, we act for on behalf of the above-named client as a result of an accident whereby during the course of his employment, our client sustained injuries due to the lack of temporary covering on an opening. Our client was caused to suffer injury, loss, damage, and expense. Yeah, that's one of the milder ones that we would get. Yeah. Securing relevant information evidence. They're saying, please ensure that, you know, there's items are secured like CCTV, etc., so we can have that and avail of that in terms of for evidence purposes. And also, if there's equipment involved, make sure it's safe. Then the other thing is, please provide access for our engineer or investigator to call to enable our own investigation. So that actually lands on your door, and hopefully you are aware of the incident and you've got records, etc., etc., etc. And sometimes people will delay it till, you know, 18 months, 19 months, 20 months, 21 months, then drop the letter in. Is the management team still the same? Is the supervisor still the same? Is the accident paperwork maintained and there available? Do people know about the incident? Again, where there's lack of information, it just increases the potential liability for the company and increases the chance of winning for the claimant. Couple of notes. When to inform your insurance company. Your insurance company will want to be informed as soon as you become aware of a potential accident or incident to an individual, where even where there isn't a likelihood of claim. Again, they will advise you as to when you should report situations to them. And the next thing is, there was a High Court ruling March this year relating to the provision of information, where a company requested, a solicitor requested access to the accident report and all the other reports associated with the incident and accident. And the company refused. And the company said, well, hang on a second. If this claim goes to court, this accident goes to court, and you know, numerous accidents do end up going to courts on us. So if it goes to courts, this has legal privilege in terms of it is part of our information associated with the accident, and we'll be using it as evidence in court. So therefore, we don't believe we should be forwarding this on. And the court agreed. So again, we want to be very careful with the information we provide and the timing of the provision, and make sure that we're not providing information that could cause difficulty. The first issue, obviously, is to ensure you don't libelous yourself or organization in your documentation overtly, shall we say. Okay, so common mistakes. Oh, no direction or sign off on accident reporting procedure. You know, so the employee hasn't been given direction on what the accident procedure is. In some cases, their supervisor hasn't been given direction, and there's no sign off to say that they've been given direction on it. Simple direction. You must report any accident or incident in work that you're involved in as soon as possible after the accident, and at least before you leave work on the day of the accident. So in that way, it's a clear direction to the employee that they must report an accident on the day of the occurrence, as close as possible to the time of the occurrence, if possible. It may not be possible, and at least before they leave work on that day. Obviously, if they're incapacitated by the accident, then that is taken, and other people are dealing with the accident, that's taken as notification anyway, because people are aware of it. Okay, so if someone comes in 2 weeks later and says, oh, I hurt my back there 2 weeks ago when I was lifting. All right, okay, so the accident report form, I didn't report it. But you signed to say you reported that. You signed to say you report accidents. It's part of our policy, it's part of our procedure, and you have signed that you would do that. Or did you do that? Well, how do we know that accident didn't happen while you were at home at the weekend or whatever? We've no control over that. Unfortunately, you know, as far as we're concerned, the accident didn't happen here. We don't have any records of it. You didn't follow procedures. And I'm going to make a note that you mentioned this today to me, but I'll also be telling you, and I'm going to be sitting down with you, and we're going to re-go through the accident procedure again. I'm going to get you a sign again to make sure you're fully aware. So that's your way to assist with mitigation. Doesn't give you full mitigation, but it's a method of assisting. Not doing the basics right. If there's an accident in the workplace and the HSA come in, they look for 4 things. 4, simple. Have we an induction for the individual that outlines the basic safety requirements, etc., and it's signed off on that? Has the individual signed up to a safe way of working, or a procedure, or an SOP, safe operating procedure, or a method statement for the work they were doing at the time of the accident? Has the individual got appropriate training in place for the activities that they were involved in? And finally, is the company managing and supervising those works effectively? 4 questions. 4 straightforward questions, obvious questions. So getting the basics right, having a good safety induction, having appropriate safe systems of work, and both of these fully signed off on, where the employee signs off to say that they will comply with. Not necessarily a safe system of work using the ladder. I'll talk about that later on. Safety training and supervision. This is where a lot of accidents can be traced back to inappropriate or ineffective supervision, where work practices, whilst they are agreed and written down and documented, they're not followed or implemented. Case in point, the ladder. Person is fully aware of how to use a ladder. They've been trained how to use a ladder. A fabulous court case with Dunn Stores. A person was in the where they have the wine and beer and spirits off-license section of the store. They were using a small ladder to place bottles of whiskey or whatever in place. Whilst coming down off the ladder, they missed a step, fell, took a case against Dunn Stores for the accident. Dunn Stores said, okay, well, we've inducted the person. We've actually trained the person in the use of ladders. And we've taken appropriate action following viewing CCTV because the person didn't follow safe procedure when coming down off the ladder. The court agreed and threw the case out. Very simple. You know, balance of probabilities. The company had done all they reasonably could have done. The person didn't follow the safe use of ladders. So let's look at poor supervision. No supervision at all, not advisable. Poor enforcement of process or procedures. Sometimes we would call that condoning, allowing people like the one in the picture to use a ladder in an unsafe way and saying nothing about it. That's the company saying, it's okay, guys, you work away. We don't have to work the way the process is. You're fine, work away. That's condoning. That's effectively, you know, putting the company in handcuffs, saying we're guilty straight away. Inadequate investigation. I mean, I did a review of a safety management system recently, and they were trying to effectively tick boxes, which is that's part and parcel of life, tick boxes. But one of the boxes was, you know, are we recording accident investigations? Are we recording accidents? Yes. Okay, so we've got the name of the person, where the accident occurred, the date it occurred, and what happened. Lovely, it's recorded, they're all there to view. My question, obvious question, okay, what happens with that information? And it's not a very good data, it's basic data, but what happens? Oh, nothing, we have it recorded. So there was nothing done with that information. You know, no investigation, no corrective actions, nothing. So therefore, the grievance is wide open. So if, let's say somebody fell off a ladder and hurt themselves, and that was recorded, another person 2 months later does the same and has a serious injury, and they say, well, it happened my colleague about 3 weeks ago or 4 weeks ago. Well, the solicitor will think, hey, we got something good here. We got the chance of making some real money, because If we can demonstrate that the company has, first of all, had something similar happen before and then didn't do anything about it, they move from negligence to gross negligence. We're into big money, and again, very easy to happen because of inadequate investigation. Little or no paperwork. Can't find the paperwork. We have some bits and pieces, Erroneous or unchallenged statements. Happens all the time. People write down what they think is best for them to write down, not necessarily what happened. We've had accident reports and we've looked at CCTV, and really, they never, they don't match. Not even close to matching in some cases. You think it was a totally different incident, the way it has been written down. We must challenge statements to ensure that they're accurate, and any erroneous issues we address and try to get right. Evidence not secured or pictures taken. The picture tells us an awful lot. If there isn't pictures taken or evidence isn't secured, well, then it impedes the investigation. It impedes getting to the causes of the accident, and it impedes putting appropriate corrective actions in place. Causes, and especially root causes, not identified. Again, not finding out what happened, why it happened, and again, putting in place then the corrective actions, because we don't know the causes. It's very hard to put corrective action in place. Weak or non-effective corrective action. Most famous corrective action from an accident. We did a toolbox talk. Toolbox talk, yeah. Fell off the ladder, toolbox talks, lads. All done, happy out, let's move on. No, that doesn't solve the problem. Yeah, it addresses an issue, but it doesn't address the basic or fundamental issues associated with an incident where somebody falls off a ladder. Liability not evaluated. So if there's a liability issue, are we trying to establish, well, where does liability stand? Now, we've got to be careful how we manage this. Obviously, we're not going to be putting everything like this down in writing, or etc. We may have discussions about liability. It's very important to evaluate liability. So, effectiveness of safety management and supervision. Robust procedures for accident incident management must be in place. If you have those, it does help, because it guides management and supervision team in the process of following through on the accident or issue. Sign off by employees, supervisors, and management on the processes within the organization. Sometimes we have, let's train the operatives. Let's make sure the operatives are trained. Let's make sure, don't forget the supervisors, because they're key to the management of safety in your operation. Get the basics right. Good safety induction, good safe system of work, good safety training in place. And focus on effective supervision. Now, we put just something very brief here, just to look at the key fundamentals of good supervision. Competent, has walked the walk. In other words, they're directing people to do work that they know inside out, have done it, and they know everything about it. Has good interpersonal skills, is able to communicate effectively with the team. Knowledge, knows his or her workforce competencies, so knows who he should direct to do certain tasks and who he should not do certain tasks. Is proactive, is always thinking about improvements, especially with regard to safety or processes. Diligent, knows exactly the status of work and issues. Letting something like that go, the chances are there's going to be an accident. Maybe not today, maybe not tomorrow, and in all likelihood, probably not one of the workers who work there anyway. Probably someone visiting or a member of the administration team coming in to look for somebody, and suddenly they're gone on the ground. Is commercially aware and acts accordingly. So knows the value of accidents, incidents, downtime, breakages, etc., quality defects. Fair, deals with everybody the same. Doesn't matter who you are, friend or foe, when it comes to work, safety rules, procedures, rules, processes, we do exactly the same. Adapts a fair response approach. So, think of how you would like to be dealt with yourself, but be fair in that approach. I tend to work on I think about giving a yellow card. The next time I actually give a yellow card, the next time oh Jesus, I could be going to a red card and polishing the top of my shoe to give them a kick up that, well, whatever. So, you know, so you have to be fair, but at the end of the day, you have to ensure that people are compliant. And you're not a babysitter as a supervisor. You know, people should be doing the work they're paid to do and do it safely. Consistent. That means that when the person comes up to you as a supervisor, listen, I know the answer, but I'm not going to ask the question anyway. You know, they can predict your decisions because they're fair, they're in line with company policy, they're in line with safety policies and procedures. So that's, you know, what a good supervisor should be. So effectively dealing with an accident incident, robust procedure for accident incident management. You know, someone is an accident. Well, okay, what are we going to do about it? Effective plans for dealing with foreseeable emergencies, including accidents. We have to have plans for emergency in place as part of our normal procedures, which is fine. Following an accident, deal with the immediate issues for the individual, which is important. Ensure the area is safe, injured person is treated, secure the area. That's all basic stuff. Then gathering information, witnesses, pictures, equipment. We gather as much information as possible, and we compile the report, which is called stage 1, which is validation of information. And validation of information is from an impartial stance. We never jump to conclusions until we have all the information gathered and go into the analysis stage. Yeah. So what we're trying to do is get the information, make sure it's accurate, make sure it's comprehensive, make sure there's no conflicts of information, etc., and try to gather as much information as possible so we can then move to the analysis stage. Yeah. Address anomalies or omissions. Yeah, sometimes you can never get everything you need or everything right, but address as much as you can. And compiling the report stage 2, which is analysis and corrective action. So an accident report analysis, only effective if all relevant information has been documented. From the company standpoint, has all the required induction and training been completed? Was there a safe system of work in place? Was it being followed? Was there appropriate supervision in place? Was the supervision effective? Now, we are going back to the requirements of the Act. Very simply, we are going back to the requirements of the Act. As we said earlier, ensuring safe systems of work, etc. From the employee standpoint, did they follow safe working procedures? Did they follow company procedures? Did they follow their training? From the accident standpoint, if procedures were followed, would this accident have happened? Now, that's a double-edged sword, really, because, well, if the answer is yes, then the procedures weren't correct, or there wasn't a procedure that was in place. Now, obviously, that is a causation factor, and it needs to be actioned. You know, there's lots of activity. Here's activity on a wind turbine, high risk, but if appropriate procedures are in place, training's in place, information and effective supervision, it can be done safely, without incident, time after time after time after time. So the question is, when incidents occur, why? Why do they occur? So accident report corrective actions. Causes and root causes need to be identified. There is a multi-cause theory, you know, and the multi-cause theory is that, you know, there was a number of different things that ended up in this happening. And that tends to be replicated 99% of the time, that it isn't just one reason an accident occurred. There are a number of reasons an accident occurs. And there is the domino effect where one leads to another. Again, lots of theory out there about it. I'm not going into accident theory today, but just to outline that there is, you know, more than one cause. Root cause. The root cause is the core issue, the highest level cause that sets in motion the entire cause and effect reaction that ultimately leads to the accident stroke incident. So corrective actions, once we've identified the causes. Amend procedures or processes if applicable. If there's amended procedures or processes, then there's associated revision information, training, instruction relating to those new procedures and processes. Discipline. Always, nearly always overlooked. Did the management fail? do they need to be disciplined? Now, when I'm talking about discipline here, I'm not saying we're issuing out warnings. Discipline doesn't have to be a formal warning, but discipline can be, listen, we've concern about your management style with regard to this. This was omitted, etc. And, we feel it was through, a lack of effective supervision or lack of diligence on your behalf. So it's documented with them and corrective actions are put in place. Supervisor, again, should discipline be considered? If they failed in their duty to discipline, to supervise effectively, absolutely, it should be considered and actioned. The injured person. And people say, actually, the poor person's, we can't. Yes, you can. If the causation factor relates to them not following a process or procedure, then we are informing of the fact that, listen, you didn't follow procedure. And the result, we're going to have to discipline you, which in this case is going to require you to be retrained and reinducted in that process. Yeah. Now, obviously, if the discipline record is a bit large, for example, ongoing safety discipline issues, well, then you may have to go further than just a verbal and written documentation. It could be a more serious offence. Evaluation of liability. This is something we need to be looking at very, very closely. As in, where does liability stand? And really, if we've had 5 accidents this year, and on every one of them, the company has a liability or significant liability to a point that the chances are we'd lose in a civil case, there's something wrong. So, question to the injured person. This is a hypothetical question. And sometimes I ask it myself, what did the company do wrong to cause this accident to happen to you? So the injured party is asked the question, hypothetically, what did the company do wrong to cause this accident to happen to you? Sometimes when I do accident investigation, I'm talking to the injured party and they say, geez, I think I have a good chance for a claim. I say, well, okay, we'll answer this question then. What did the company do wrong to cause this accident to happen to you? And if they think about it, then point is going further with it, because it should be very, very obvious. So we need to be thinking that way. Evaluate the question from the employer standpoint. What did we do wrong to cause this accident to happen to that individual? Evaluate it from the supervisory standpoint. What did the supervisor do wrong to cause this to happen to the individual? If anything, he may not have done anything wrong, or she may not have done anything wrong. And then the company's standpoint. So we look at it from those standpoints to try to evaluate liability. Remember, 50.01% on the balance of probabilities. And if we can get our side to be over the 50%, then we're in a strong position, providing that the individual has some level of cause to the accident themselves, to try to stop this from progressing early on. We have to evaluate contributing negligence, and that is the percentage that the company have liability and the percentage of the employee liability. Again, we're not writing this down as such. This is kind of a discussion with the management team to evaluate, and a safety department or consultant or whatever, to evaluate liability. And then ensure that appropriate action is taken to address the corrective actions that needed to address the negligence identified, which goes back to the corrective actions as outlined before. So, steps to mitigate. Have an effective and safety management system in place and implement same. Have a robust accident investigation and gather the right information. Do a comprehensive accident analysis. Implement corrective action. Mitigate liability. And that's all, we're always thinking to reduce liability continuum. So 2 liabilities we're trying to reduce. Reduce the risk of accident or injury to individuals. Reduce the risk of potential claims on the organization. Initiate disciplinary proceedings where required. That helps mitigate liability. Deal effectively with solicitor's letter. Yeah, this is what, if everything's in place, what you should do. Outline the provision of information and training to the individual. detail what the individual has signed off in terms of procedures, etc., including the procedures that they were working to at the time of the accident or incident. Detail any disciplinary action taken as a result of the individual's behaviour or lack or failure to comply with the procedures, if it is applicable. Refute the assertions that the company has a liability. Again, you can only do this if the company is in the position where they have procedures in place, effective supervision in place, etc., and can demonstrate same. If you don't, then it's very hard to go back with this information to the solicitor. Vigorously suggest you're going to defend any action taken. You're not going to take it sitting down because you don't believe you have a liability. Okay. So what is the percentage then of the percentage of success? In our experience, over 90% of letters that come in do not progress to claims if you have everything in place that you should have. And that is if the accident, in terms of the individual, because of their behaviour, they were the primary cause of the accident or incident. Obviously, if there's issues with regard to process or procedures or supervision, etc., well, then that makes it very difficult to address. So they can be smiling with a lot of money in their pocket, or if they were at fault, they shouldn't be. But as we know in Ireland, it happens day in, day out, where people make claims for damages that may not necessarily be accurate or true. And in a lot of cases, they're to blame for what's happened to themselves, and the system operated by the organizations and operated in terms of the way the legal system works facilitates successful actions by themselves. So there is a concerted effort to try to reduce cases going forward. But as I said at the beginning, your objective should ultimately be to reduce the potential for accidents and incidents to occur in the workplace at all. So, in summary, I've outlined the legislative requirements. I've outlined the state's enforcements. So, what happens, how the state works, the civil proceedings, the common mistakes that are made, the effectiveness of having a safety management system in place and effective supervision, how that can make a significant difference, how to deal with an accident or incident, the evaluation of liability once you've done a very, very good accident analysis of the incident and then put corrective actions in place, and the step to mitigate or address liability in terms of should someone try to proceed with taking a case against you. Yeah. So that's it in terms of the presentation. What I'm going to do is I'm going to stop the recording.